Nsem-Pii TV nie.
Bold to defend forever the cause of freedom and of right. Yamama kwa baba Nsem-Pii TV so. Electoral Commission are announcing electoral results from the by-elections from Asen North. Gyakye and a member of parliament for Asen North. But the criminal trial still persists. Share the way lawyers of Gyakye, lawyers from the Attorney General's office, on case management, na obia bedding ebe argue case in the criminal trial. First point of action, and parliament resume. Members of parliament, Speaker of Parliament, Alban, Kingsford, Shumana, Babin, Enya quorum because na be brain na to kwanko Asen North into a more banner na quorum hunyano aye dene. Nanso Speaker of Parliament join Daily Graphic or person boosting Parliament ni media relations. They go straight to the Accra High Court. Lawyers of Gyakye adopted a certain strategy from before the by-election. That is, postpone the criminal trial after by-election. But successfully, I go through the electioneering period and come out victorious. Now the next strategy adopting is delay. First point of action here, call Court of Appeal. Appeal Justice Yanzu ruling or the by say Gyakye in criminal trial on a daily basis. Now this application ni kotumu and almost answer another application for stay of proceedings ekotumu Accra High Court. Now saying yet ya pese amount full documents na bibi ancheche mu kakra pese no near den ye aba. In the Superior Court of Judicature in the Court of Appeal Criminal Division dated 27th June 2023 10:40 a.m. and accused applicant and appellant in Eden James Gyakye versus the Republic, prosecution, respondent, and respondent. Inti omonomode case Akodam Court of Appeal versus the Republic. Notice of interlocutory criminal appeal, Rule 59A of CI 19 of 1997 as amended by CI 25 of 1995. Information there say please take notice that the accused person, applicant or appellant herein who is dissatisfied with the decision of the High Court Criminal Division 3 Accra presided over by her ladyship Mary M. Yi Yanzu dated 23rd June 2023 hereby appeals to the Court of Appeal on the grounds set out in paragraph 3 and will at the hearing of the appeal seek the relief set out in paragraph 4. There were Kaya Cocoa Board case now so ruling way back near a court appeal, ruling way back near a court appeal, ruling way back near the court. Sa ama new judge but now so Justice Honyanyuga call retirement, new judge but now so at the ruling by starting a whole lot afresh. Inti sa strategy here or more adopted, we better make say, is it in anticipation of the winning of political power, normal influence things in the judiciary now, time and posterity, and the ultimate judge. Now, part 2 of this application to the Court of Appeal, part of the decision complained that the refusal by the court below to review and or vary its decision of the 16th June 2023 at the behest of the Attorney General ordering the day-to-day hearing of the trial and fixing of 20th to 23rd June 2023 for continuation of the trial. Ebekaya lawyer Poivra Teriwaja and na oil lawyer for James Gyakye. Attorney General Enso and one of the lead lawyers for the Republic. And omo buy into consensus the case ni the SA anything in tempara. But one was of the view say yen no day to day during the campaign season, and another was of the view say yen day to day after the campaign season. We edin kasa kasa ne ntawantaba bi by, but justice her ladyship Justice Yanzu Erule say omonye on a day to day trial. And biana lawyer Tsikata edi appeal ebim ene holidays yedin ebe PM a omotimi koye elections. Nti pempen so aye dru ye omo kwa appeal this particular ruling Justice Yanzu de by Court of Appeal say day-to-day trial no ebe unfair, especially in the case say vote ama James Gyakye as uncle representing member of parliament. Obasan so argue on the ground to say parliamentary sittings ebe koso ebe resume enti ebe good ne fair say enti time would be available to prepare more for the case. Enti a court of appeal either say obeka say Justice Yanzu ruling no the by no ewo fapem wo law mu ana say any fapem wo law mu na omode court of appeal decision but in the meantime and serve this form of interlocutory criminal appeal document command her ladyship Justice Yanzu ewo Accra High Court to say on granting stay of proceedings pending ruling from the Court of Appeal. And yenko the paragraph 3 ground of appeal no so. The court below erred in law when it failed to appreciate that the exercise of its discretion on 16 June 2023 in respect of the grant of adjournment violated the provisions of Article 296A and B of the 1992 Constitution, as did the exercise of prosecutorial discretion by the Attorney General. In the provisions of Article or usually Article 296A and B of the 1992 Constitution, and then in the ground or they appeal the day-to-day trial ruling Justice Yanzu by particulars of errors of law. The court below's invocation of the trite law that adjournments are a matter of the discretion of the trial court made it oblivious to the requirements of Article 296 of the Constitution, which requires that every such discretion be exercised fairly, candidly, and devoid of arbitrariness and capriciousness, and not based either on resentment, prejudice, or personal dislike. And the ground of appeal, and what they are to grant say, sad decision it lies in the discretion of the court. Data almost set for almost decisions, say almost here case no, based on then exercise fairly, exercise candidly, devoid of arbitrariness, capriciousness, and not based either by resentment, prejudice, and our personal dislike. Based on the argument of the lawyer of James Gyakye, or to me prove or court of appeal say, Sani me a man Justice Yanzu edisa ruling whereby na resentment be woman na prejudice be woman na personal dislike be woman out of personal sentiment. And James Justice Yanzu decided say or ruling say omunye day-to-day trial and as based on personal sentiment. Say any grounds on whether it will hold or no will be based on the court of appeal. Second, The court below failed to give due attention to important considerations such as constitutional rights of the accused in exercising his discretion. Enti, certain constitutional rights judge of the Court of Appeal bebusa no ne say emu dien na court no etiamra regarding the day-to-day trial, because court no has a right to hear the case and an individual to has a right, certain right or be exercising as a citizen of the Republic of Ghana. Inti emu din and a court no ebu mu enimtia, because court in there no try to obey a favor now we're making sure say you be hear case as early as possible so you be able to go ahead now why any gap in normal business. Now B, the court below erred in law when it claimed that matters brought to its attention by the accused regarding the abuse of prosecutorial powers with extremely prejudicial implications and an insult of the accused persons and professional misconduct by the Attorney General in respect of this case were not relevant to his consideration of the review application. Anti accusations are lawyer Gyakye against Attorney General no Justice Yanzuka said and no one relevant to the decision in making a review on the day-to-day trial no was also the Aba Court of Appeal say omonyere omonsan so nhwebium near san kan bium or say the court below erred in law when it claimed that matters brought to its attention by the accused regarding the abuse of prosecutorial powers with extremely prejudicial implications and an insult of the accused persons and professional misconduct by the Attorney General in respect of this case were not relevant to its consideration of the review application. Enti saa seminar lawyer Tsikata koka say Attorney General kojina media nso ekanye say James Gyakye case ni say Abusa kan the case no say prejudicial no. Justice Yanzuka says our statement na in relation to civil matter. Until there is no way relevant to our criminal trial where cost into one so and review the decision and an ruling so a day-to-day trial. Was also the Aba Court of Appeal so emano particulars of errors of law, prejudicial statements made by the prosecutor, the Attorney General seriously affect the fairness of the trial. And also see one issue. Second issue, the court below completely abdicated its constitutional obligation under Articles 12 and 23 of the 1992 Constitution to ensure that administrative officials carry out their duties reasonably. 3. The court below also abdicated its inherent powers to ensure that its officers conduct themselves in accordance with the standards required of them under the rules of professional conduct and etiquette. In total, prosecutorial powers of the Attorney General and one of the main reasons are all listed say or they by the Court of Appeal. In the Court of Appeal, the ruling in Baba, a party said go against the prosecutorial conduct of the Attorney General. Whether that will hold or not, will depend on how the Court of Appeal be ruling and how our Attorney General argue in the case in court. Also to also with 4, the issue of professional misconduct of by the Attorney General, which were brought to the attention of the court below by the accused persons, appellant and applicant, were additional reasons for the court to have reviewed the decisions it made at the behest of the Attorney General for day-to-day hearings. And 5, the court had on 21st June 2023, at the hearing of the applicants for review, ruled that the supplementary affidavit which provided further evidence on these allegations was relevant and admitted that the said affidavit in evidence on that ground, but now changed its position with no legal basis. In TC, where some of the 5 reasons are well listed, say a particular errors in law, Court of Appeal for about the High Court and ruling and Now, C. The court below erred in law when it failed to appreciate the significance of the rights of the accused persons contained in Articles 19.13 and 21.3, as well as Articles 19.1, in respect of the necessity of a court when exercising its discretion to consider all relevant factors. Particulars of errors in law, constitutional provisions refer to establish important constitutional rights which must be enforced rather than being curtailed as a decision of the court did. Another issue here, D. The court below erred in law when it invoked Section 169 of the Criminal Procedure Code as if that section requires or justifies a criminal trial being heard day to day. And today, ɛho nsɛm ara na lawyer Chachu challenge it with various sections, various paragraphs, various provisions in the constitution. Sɛnea challenge Justice Yanzu ruling ɛwɔ Accra High Court. Moving further to another particular errors in law or claim say Court of Appeal for nhwɛ and then reverse the decision of the Accra High Court. The terms of the section regarding grant of adjournment make no reference to day-to-day hearings of a trial. E. The court below erred in law when it failed to appreciate that on 16 June 2023, it did not have jurisdiction to hear and determine the oral application made by the Attorney General without prior notice to the accused and his lawyers for a significant change in respect of the fixing of date for hearing of the case. And the Attorney General's lawyering statement or making on the floor, no, or say nanka say then the court and jurisdiction just encounter prior notice to the accused and the lawyers for significant change in respect of the fixing of date and for hearing of the case. Now, particular errors in law. The court below did not address the issue raised in the application for review that it did not have before it on the 16th of June 2023 any application or notice by the Attorney General to the accused and his counsel concerning the fixing or hearing of date for the trial day to day. And the court below acted in violation of due process of law, thereby contravening Article 296B of the 1992 Constitution. F. Decision of the High Court were per incuriam, a binding decision of the Supreme Court, Republic versus High Court, Commercial Division A, Tamale, Ex parte Kalim, 2015-2016, 2 SC JLR 1332, and therefore in violation of Article 1294 of the 1992 Constitution. Now, particulars errors in law. The said decision of the Supreme Court makes it clear that it is within the inherent jurisdiction of every court to review, vary, or modify order it has made in circumstances such as those brought to the attention of the trial court in the application of the review. Reliefs sought from the Court of Appeal. First relief, a reversal of the ruling of the court below dated 23rd June 2023. And 5. Person most directly affected by the appeal, the Republic, the respondent, and the respondent. Address of the appellant, Asimbreku Central Region, and dated at Kaponde and Associates, Ghana Supply Building, blah blah blah, Cocoa Board. Lawyer of the accused, Justin Poirva Teriwaja, or no, the same person or drafted sa letter where or sign it, and then signatures, I think. Aboso fe or no and Odessa appeal we Akodom Court of Appeal led by the very knowledgeable lawyer Chachu Chikata against the Ngolo Kante of all lawyers, Attorney General Godfred Odame. It's way very interesting how the Court of Appeal may hear this appeal of basically the day-to-day trial ruling of Justice Yanzu against James Gyakye and the Republic of Ghana. Interesting times ahead. What is the focus of the government in particular in this James Gyakye case? Is it about time to move to other matters? and as a still they are bent on ensuring say criminal trial will be. Now, is there a possibility of another by-election? And as saying not, should the ruling go against James Gyakye? Even if it goes against, it is going to be long overdue because Senate even several matter and court of appeal, various levels. Echo PM, a friend is saying Supreme Court, and also a lot of challenges. So now, but say we are in 2023, halfway into 1.5 years to another election period. Untimi nim say this focus will shift the focus of the government in power away from developmental projects to court hearings. Now, maybe the NDC wins the elections and become leaders of the republic now. On Betimaya, then deal on my concern, withdraw case now if court. You don't know. And the Court of Appeal application now, James Gyakye and then lawyer Poabra Terigwaja and a lawyer Gyakye Kata, they are Court of Appeal. And they are Bremo in Nsem-Pii TV. So me didn't quite know Mena Medesa editorial way adding a brem. Please subscribe to Nsem-Pii TV.